So anyway, I'm going to talk today about, we're going to talk about community associations and foreclosures and cancellation of debt. Looking at the slides here, as you're probably aware, most new developments are designed as community associations, nothing like having a gate-guarded community that developer can charge more. For the little booth at the entrance, put some fences around the place, so most of these new developments are community associations. You can see here that there are many people living in HOAs. Nationwide in California, 13% of we have 13% of the community associations in the nation here in California, second only to Florida. I wouldn't say our statistics are real accurate here, but there are 45,000 community associations, CIDs we call them, in California, and 25% of them are here right in Los Angeles County.
So our practice is to work with volunteer boards of directors who are charged with the responsibility to run the association, including running and taking care of its financial affairs. And there are times that board members have never done anything related to finances other than possibly balancing their own checkbook previously and not having worked within a budget in their own lives. And those are the people that are on the boards because they want to protect their interests. And so our job is to help them do that. Because board members touch money, they are fiduciaries just like any other entity or person that has the responsibility to care for the assets of somebody else. And the obligation to collect assessments is part of the fiduciary duty based on the obligation to enforce the association's governing documents. And the obligation to levy assessments and then collect assessments are both set out in the Davis-Sterling Act and in the association's governing documents. Clearly, one homeowner in a small association who doesn't pay their assessments could interrupt cash flow. During the height of this financial meltdown that we're coming out of, we had associations that were 25, 30, and 40% delinquent. Just shocking numbers in the Inland Empire or in Stockton, California, where literally clubhouses were locked shut and amenities were closed and not open for use. Assessments are the only source of income for most of our community associations. It's only the very large ones that have club services or golf courses that might have additional sources of income. But when a board of directors budgets their annual prepares their annual budget and levies the assessments, the statute says they can only levy those assessments for what they actually need to do the work that has to be done the next year. So it's pretty tight. And if one or two people stop paying, it obviously can have a very negative effect on the association's ability to do what it's supposed to do. The board has an obligation by law to do everything that they can legally to collect the assessments. And for the longest period of time, boards didn't want to take action because they felt it was spending money that they didn't have and that homeowners were not going to pay their assessments in any event, so why should they bother? But as we tell our clients, that's not an option. Doing nothing is not an option. Maybe making a decision to do nothing, that could be an option. Otherwise, the board has to take action because it's one of the enforcement things that they have to deal with. Most associations' governing documents allow for the recordation of liens for the non-payment of assessments. We have an act called the Davis-Sterling Act, which is part of the Civil Code that controls the legislation for homeowners associations. And in order to be a common interest development under the Davis-Sterling Act, you have to have two things. One is the ability to record liens, and common area or at least reciprocal easements from owners to the association or from owners to each other so that the association gets its authority to collect its money. The lien, when it's recorded against a homeowner's unit, is for the delinquency that is in effect at the date the lien is recorded. Interest late fees, and reasonable costs of collection. The lien amount, it increases every month along with the delinquency amount, so that if you go through a foreclosure at the date of the foreclosure, all of the costs and fees, including assessments for that entire period of time when the unit is going through the foreclosure process, will be included in the foreclosure amount. The lien places the association in a position to be a secured creditor, which clearly, because we had such a high rise and influx of bankruptcies in the last couple of years, is incredibly important for an association. If you're not a secured creditor, obviously, you don't have the standing to go after an owner or go for what's called a relief from the automatic stay, to ask the bankruptcy court and the trustee to let this property outside of the bankruptcy. We were making those arguments, saying that they are not in any way enhancing the bankruptcy estate, and relief from stays have been prevalent really for the last 5 years, and 5 years before that, in the last real estate cycle, or downturn, the same thing happened. There's 3 methods for collecting delinquent assessments. One just has to do with money, and 2 apply to the property. The first is suing for a money judgment. When you sue for a money judgment, you're suing for the money that is owed as of the date of the lawsuit. It's finite. You can add your interest, costs of collection, and late fees to that lawsuit as well. But it doesn't do anything about a homeowner that's living in the property who is not making any payments to the association for the assessments. And so you're not going to get to the heart of the problem, or cut out the cancer, as I like to say, and having the person who's not removed being removed from their unit. The other 2 methods are judicial foreclosure and non-judicial foreclosure. So judicial foreclosure is part of the judiciary process, meaning you're going to file a lawsuit and you're going to go through litigation to, at one point, the court is going to say that you have the right to go after a money judgment, which is like option number 1, or you can go after and get a court order to foreclose. I sort of think that's like that famous case that says, why use a cannon when a pistol will do? Because in judicial foreclosure, you're going in to get a court order, when under non-judicial foreclosure, you have a right to foreclose within the statutory framework without having to file a lawsuit and without having to ask the court to say, yes, you can go through the foreclosure process, because the statute allows that to happen in any event. In California, non-judicial foreclosure is the preferred method of assessment collection. It's more effective, it's quicker, it's faster. I am biased, by the way, because our law firm owns an assessment collection company, so I want to be perfectly clear, I am biased. But we do judicial foreclosure as well in the law firm side of what we do. And I just think it's a great benefit for me, because we make a lot more money doing litigation, but I don't think it's a huge benefit for the associations. This is for you.
All right. Getting back to what you was talking about, does an association have to foreclose? The answer is really no. In fact, I've worked with a lot of HOAs. They don't want to foreclose. In fact, they don't even want to follow their own written collection policy, because they let their emotions in and they feel sorry for their neighbor who may be unemployed or be sick, or comes up with all sorts of reasons why they can't pay, which may be legitimate or may not. Some of these people who are, I'm going to tell you quite honestly, are saying they can't pay. They're making their car payments, they're making their mortgage payments, and these cars they're driving around are really nice cars. All right? So the last thing that they're saying, I don't have money to pay my homeowners association, which probably could be paying for utilities, insurance, on the buildings, on the common areas, the pool service management. So it's hard to tell sometimes what people's situations really are. Anyway, the association doesn't have to foreclose. I do say they should follow their written collection policy. The advantage of non-judicial foreclosures, you can see on the slide, is the board can stop if they want to at any point, but with judicial foreclosure, I think it's more difficult to stop the process. My experience, mostly with judicial, unlike Sandra with non-judicial, is with judicial, the fees charged by the attorney are added on to the homeowner's account, so it just gets worse for the delinquent homeowner. But if the board should decide, well, you know, we really don't want to pursue this, or we want to stop, then all of a sudden those fees, which may be discounted by the attorney, are billed to the homeowners association, who all of a sudden gets a big, you know, legal bill, which they were surprised because they thought they weren't going to have to pay. But again, if they stop the train, switch horses, and delay things, the homeowners association is going to end up paying for these legal costs. Bullet point number 2, after a notice of sale is recorded, a non-judicial foreclosure, as we said, could be postponed for an unlimited number of times, trying to work things out with the homeowners. I always tell the board members, why don't you get the homeowner to come to a hearing, find out what the story is. Again, you don't have to consider what they say, you don't have to believe what they say, you don't have to have all the board members to be there, but at least you're communicating with the delinquent homeowner. As Sandra and I would agree with the third bullet point, choosing not to foreclose really doesn't solve the problem. In fact, we were talking about a few mutual clients where the amounts owed are substantial because the board didn't do anything, kicked the can down the road. Some of these homeowners, believe it or not, are pretty good at putting off creditors, declaring bankruptcy, which sort of puts everything on hold, coming into the board with a payment plan the board agrees to, and then the homeowner doesn't stick with the payment plan. And some of these homeowners are really good at knowing how to delay and not paying. I can tell you from experience, and again, I have a regular job where I teach, but working with some homeowners associations, I've seen balances of $20,000 to $40,000 owed, and the dues aren't, I mean, they're not Wilshire Boulevard type high-rise properties where the dues are substantial. We're talking maybe $250 to $375 a month, and these people haven't been paying for 4 years.
Somebody was asleep at the wheel for a long time.
Yeah. Yes. Another interesting thing is some of the non-payers are the ones that are investors that are renting the units, collecting the rent. We're going to get to this point, and not paying the homeowners association's assessments.
You can imagine that would rub all of the board members who deal with this the wrong way, as it does me. So anytime during the collection process, the homeowner can bring the delinquent account current in order to avoid foreclosure, and by statute has the right to ask the board of directors to consider a payment plan. The statute doesn't require the board to agree to a payment plan, but it does require the board to agree to entertain a proposed payment plan from the delinquent owner. We usually will tell our clients 50% upfront on the debt and the rest to be paid out over a 6-month period of time would show a very good commitment. We sort of come up with a 6-month plan based on successive diets. You can stay committed for a certain amount of time, but after a while you fall off the wagon and people find different uses for that money that they were going to allocate to pay their assessments during the payment plan period. So why do we foreclose even if there's no equity in the property? It's because the association has the obligation to enforce its governing documents and collect the assessments. And if they don't collect the assessments, they need to move the property interest along and get that owner out of the property. There are many times, dozens and dozens and dozens over the last 3 years, where on completely upside down properties, homeowners will come forward and pay these delinquencies and get involved in a payment plan where they're showing good faith. And one of the reasons is if they're not in the group that Ron was talking about, the $20,000 to $40,000 group, but let's say they're in the $5,000 to $10,000 group, paying off their delinquent assessments, especially if they're current, or trying to make good on their mortgage is a lot cheaper than going to rent a new place where you're paying first, last, and a security deposit. And some places require 2 months. And in areas where that has happened, we have seen an increase in homeowners trying to get back on track, because if they're out of the property, they have to find someplace else to live. And you can't win at the game of collection if you don't play the game. And on the courthouse steps, we have many homeowners that will really come up to the steps and literally redeem their property at that time. We've also seen a big surge in the last 8 months or 10 months where properties that I would still consider and you would consider still upside down are being investor purchased at the foreclosure sales. They think that they're close enough to value that they can purchase them and put them on the shelf. So why foreclose? It is the only way that we can get the delinquent owner out of the property. Heartless? Maybe, but this is a business situation. Associations, although they're the home of the people who own property there, it is a corporation, it is a business, and has to run like a business. If you can collect rents, great. We'll address the rent skimming issue in a moment, or you should confer with, if you represent associations. Anybody here work with homeowners associations? Okay, this is all new territory. There's a rent skimming law, which I'll discuss in just a few moments, and there's a question of whether or not renting out the property once the association becomes an owner and not paying the obligation of the first trust deed will subject an association to the civil or criminal penalties of the rent skimming laws. And so as attorneys, we'll try and work with associations and figure out whether this will or won't apply. Sometimes the association going forward and completing the foreclosure will force the senior encumbrances to come to the table and foreclose. I have associations, they'll sit for 3 years and finally make the decision because the first trustee is doing nothing. Then they foreclose, and then immediately in the next 60 days they get notice that the first trustee is foreclosing. And they're like, why did we do that? We spent that money, we went through this process. Because the first trustee didn't want to move until there was no place else for them to go. They don't want that property back in their portfolio any more than we want our associations to actually own a unit. But sometimes that's the only way that we can get movement on this debt and get a paying owner into that property. That's the goal. Somebody who's going to meet the obligations to the association on a monthly basis. And the last bullet, of course, is that a third party may purchase the property, and that actually can happen, and it is happening. You never know what is going to motivate a third party purchaser to acquire the property. If the property is sold to a third party purchaser, then there's 100% recovery of the association's debt. They cannot close the foreclosure without paying everything that is owed to the association, the legal fees, the cost of collection, interest, late fees, the whole litany of things that could make your eyes roll, but it's the debt that the owner owes to the association. How do I know conclusively it's going to be 100%? Because the opening bid at a non-judicial foreclosure sale for a homeowners association is that exact amount of money that the homeowner owes the association for all of the things that I just referenced. So we know as of that moment, if somebody buys it, the association is going to be covered. If there's extra money, if there's actually a bidding war at the sale, I can't wait for those days to happen again. But if there's a bidding war at the sale, the overage over what the association's opening bid is, it goes to the owner who is being foreclosed on. It's not an asset that will go to the association. Big rub for homeowners associations and for investors, and that is that a homeowner has 90 days after the sale to change their mind and say, just kidding, I want to redeem my property, I'm going to pay. And in order to redeem the property during the 90-day period, they had to pay everything that was included in that opening bid, and they have to pay everything that is accrued against that unit since the date of the sale. So the obvious, assessments, interest, trustee fees, if there are any legal fees, late fees, and if the association has expended any funds, insurance on the unit. There's a case where an association jumped the gun, a third-party investor jumped the gun and started refurbishing a kitchen, and did refurbish a kitchen, and on the 89th day, the homeowner redeemed the property for everything except for the money in the kitchen. And in an unpublished trial court decision, so unpublished, we can't rely on it, but we could talk about it with envy, the court said, you know what, that money was put into that property and you don't get a gift, and the court required the homeowner to pay for the upgrades in the unit. I don't know if we'll ever see that happen again in a court, because that wasn't necessary to the unit, but the purchaser said, yes, it was. The property could not exist in its current condition. If the association does not receive money, the obvious is that it gets the property, and that property will satisfy the debt. So we have boards that go all through the process. We explain to them all along, if I don't, Ron does. If he doesn't, the manager does. And they call the day after the sale, and we say that the property is reverted to you, the association owns it, and we're going to let you know what your options are. Okay, but when are we going to get the money? You don't get the money. You get the property or the money. And they're pretty clear on that, although when it's over with, they seem to have amnesia just a little bit. We say that the property reverts to the association, which is really an enigma because it never was owned by the association. The reversion language is a carryover from first trust deeds and senior encumbrances, because we use the same code for non-judicial foreclosure in assessments as we do, homeowners assessments, as we do with senior encumbrances. So now what? We own that unit. What do we tell our clients? Well, if the association is now the proud owner of this unit, they own it subject to senior encumbrances. So when the senior encumbrances wake up, and it can be the first or the second, and say, oh, no, we're just joking, that's our unit, they can foreclose out the association's interest. And we want them to do that, and we want them to do that quickly, because they're going to be our owner that's going to be responsible for the payment of those assessments. So an association that's not poor and has some tolerance for sitting and waiting can do just that. They can do nothing and allow the bank to foreclose. They can contact a real estate agent, attempt to short sell the property, not commencing that action until after the 90-day redemption period. I don't like that. I think it's risky to the association. The first is not going to talk to the association unless they become the obligee on the loan on that property, and the association has no obligation on that loan. So we don't have, our homeowners associations do not belong in the real estate development or ownership business. We say, this is not your opportunity to think you're going to make a killing. You're fiduciaries. You're just supposed to get that money back from the delinquent owner or another source. But we don't want the associations really to step in and go through that process, because what happens if that short sale falls through and now the association has obligated itself as the owner on that underlying debt, even on a short sale? It's a lot of money. Or can lease the property after the redemption period, subject to the rent skimming laws.
All right. I've got a question for you. What happens if it's owner occupied?
If the property is owner occupied after the foreclosure sale and the 90-day redemption period, you go through a unlawful detainer action on a 3-day notice to pay or quit.
And how long how do we get the owner out?
The sheriff goes in and removes them once you get the order.
And how long will that take?
Usually within 7 to 12 days. Now, there are people that hunker down and lawyer up at their last desperate act, and then, of course, it makes it more difficult. In the 80s, it was much more easy for them to hunker down because title companies did not understand non-judicial foreclosure. They didn't feel that there was protection in lien priority. They didn't feel that it established a good sense of ownership of the property, but not so much anymore. You show this order to a sheriff in the 90s and the 2000s, and they know what it is, and they know the authority exists. Yes, sir.
When you started, you said that the association only had the right to assess dues for what they have to spend next year. How do they build reserves?
The question is, I had said that an association, when putting together its annual budget, only has the right to levy assessments for what they're going to spend for the next year, and how do they put together money for the reserves. That's part of the budget. Associations are required every 3 years to conduct a visual reserve study of their property. We always recommend a certified reserves fund specialist, and that specialist will provide an estimate to the board of what contributions they should make to the reserve fund on an annual basis to meet this 30-year projected plan. So it is part of the budgetary process. Also part of the budgetary process is a line item for bad debt. And we were recommending that associations really budget at least 10% based on the numbers we were seeing for bad debt, because if you had so many owners in delinquencies, the associations would be in a position where they could not meet their basic obligations. Go ahead. The question is in shock, really. The association can foreclose and they don't have a responsibility to pay the loan. Ron is going to talk about that in a few minutes, so I'd like to just hold on that for a second. Gentleman in the purple shirt.
The repair study should be done every 3 years, but should be done by certified specialists.
There are the question is, a reserve study should be done every 3 years, and I said by a certified reserve study specialist. There are people who have designations, just like accountants, just like attorneys, where their designation is a certified reserve fund specialist, and they learn how to break down the components of an association to identify, based on a 30-year plan, the useful life of all of the major components at the association. And you will also do a 1-year follow-up. You don't need to have a visual inspection in years 2 and 3, but if there had been a major change at the association, let's say in year 2, the association put on a new roof, then you'd want to have there to be an adjustment on the reserve study, especially if money was being set aside to purchase a new roof. We're going to take one more question right now, sir.
What's the redemption period on a judicial foreclosure?
The redemption period, the question is, what is the redemption period on a judicial foreclosure? The redemption period on a judicial foreclosure is on the front end when you foreclose on the completion of that foreclosure. In judicial foreclosure, it's a done deal. So there is no ability for the owner to bring an action for redemption unless there was a fraudulent foreclosure, which of course is what everybody contends in order to try and to keep the association from going forward in their ownership. Ron.
Okay, so this next point where I started out asking Sandra a few questions was if it was owner occupied, but now the question comes up, what happens if it's tenant occupied? And there is sort of this redemption period, 90-day period. I'm not sure the board realized that they were going to end up with the unit, but they did, okay? So during that period, it's sort of vague as to whether what they should do, but here's what we think they should do, and that is being tenant occupied, they contact the tenant, right? Tell them that the former owner is no longer the owner, and also tell them that the check should be now made out to the homeowners association and not to the former owner. Of course, they'll probably ask for some evidence and proof, but show them the paperwork and might require a letter from the HOA's attorney. But now we're collecting the rents.
Anybody here know what assignment of rents is? Assignment of rents is a provision that in what I consider to be well-drafted CC&Rs, covenants, conditions, and restrictions, the governing documents for an association, allows for the association to step into the place or the shoes of an owner of the property who is delinquent to the association, stand into the shoes and make a demand on the tenant even before this foreclosure occurs to get to that money. And last year, the legislature made it rather easy for associations to do that. There's 2 forms that have to be filled out. They're turned in. You get a court order to certify the assignment of the rents, and you serve that on the tenant. And the reason that tenants will pay on an assignment of rents demand under that scenario is they are indemnified. The owner of the property cannot get rid of them for non-payment of rent if they actually paid their rent to the association under an assignment of rents order. So this is a very important provision to have in CC&Rs. We always recommend to associations that they try and amend their documents to add this provision.
Sandra, a couple questions. You need to explain what CC&Rs are, if you would, and also, does the assignment of rents provision have to be in the CC&Rs for the association to be able to obtain the rent?
The assignment of rents provision must be in the CC&Rs if you're going to try and get to the rent before you foreclose on the unit and it becomes an ownership asset of the associations. Doesn't mean that associations are not going to make a demand on the tenants in any event, but it is somewhat problematic to enforce without that provision in the CC&Rs. CC&Rs, covenants, conditions, and restrictions. A covenant is a promise. The CC&Rs say in the body of the document that I promise I'm going to pay my assessments to this association for all the things I'm getting in my property and the clubhouse and the common area. And that obligation runs with the land. It is a recorded document and it binds all of the properties that are part of that association. So the argument from people, oh, I didn't know I was part of association. No, they can't make that. You can't close escrow in California without saying that you've received and read the CC&Rs. A good stack of CC&Rs is about this thick, and you usually get them at escrow, so you're just signing those papers that you read them and you understood them. I never really understand how that can actually happen. All right, so after this process, we talked about the 90-day right of redemption previously. The right of the redemption is going to give the owner the ability to get that property back. And I think I've already just defined what it is. But just know that until that 90th day is complete at midnight, that homeowner has that right. We've had, as boards of directors, ask us to record the notice of sale at 5 o'clock or 4:59 before the clerk's office closes on that date, and we won't do it because we really think that we have the full time towards the end of that day in order for the homeowner to redeem. And we've had redemptions in an evening, not quite that late in an evening over the years. So an association doesn't have to take any action other than to place insurance on the property. But we have to look at what the issues are by breaking them out. What are these associations' responsibilities? There is a maintenance responsibility to the common area. There's going to be a maintenance responsibility to the unit as well. You want to have the unit checked on periodically because if there's a water leak or some event that could cause exposure to the association or other owners, if there's not somebody residing in the unit, we don't want this maintenance responsibility to create an additional liability or burden. Insurance, some insurance brokers say you don't need separate insurance for a unit because it's common area and therefore it would be covered under the association's master policy. Some say you do need separate insurance. I'm all for separate insurance. I wouldn't want to take any chances. We had an association in Hollywood, and there happened to have been a squatter living in the building. That board chose not to get insurance. Their insurance carrier said that the unit was not covered, and this person fell off the counter and broke their lower back and their leg, and here this guy was a squatter in their unit and exposed them to a liability. Mortgage, no, we already talked about that the association is not responsible for the mortgage. Taxes, sort of. I'll talk about that in a little while, whether you do or not pay taxes on the property. Rents, you want to keep them from the tenant, you want to collect the money, and the tenants, you are obligated, if the association forecloses, to honor the current lease that they have with the owner, and why wouldn't we want to do that? Money will be coming in. Before you take the next slide, we have a question.
Two questions. Isn't there an assignment of the rents in the senior trustee? What does the second assignment do? And at the redemption at the 90th day, do they have to have all cash immediately, or?
So there are two questions. One, at the 90-day redemption, do they have to have all cash or certified funds? Yes. And although, do you know you can stop payment on a certified fund check? Yeah, we just had that unfortunate knowledge. So be careful on that one. And then, yes, a first trust deed has, in almost every senior encumbrance document that I've seen, also has an assignment of rent provision. Courts do not look favorably on senior encumbrances that don't move forward to protect their rights, then let another entity go in, do all the heavy lifting, and then wind up giving them money. What we say to associations, if they're going to collect rents after foreclosure, that they open up a separate account. And for the first year, if they're renting that property, they put that money in the separate account, and they don't touch it, just in case the first trust deed wakes up and makes the demand. We have never heard in the state of California or any of the western states where a demand has been made on an association by a first trust deed for those rents, but it could happen. And it could happen based on the very premise that you raised. I'm going to take one question here, and then we're going to continue going.
When you mentioned that CCNR is required prior to close of escrow, does that include financial statement and future R&R budget?
Repeat the question.
Yeah, okay, the question is, what does escrow ask for, or what is the prospective buyer going to get from the association? Really good question. They're going to ask for lots of things. The escrow company is going to ask of the homeowners association or the management company, articles of incorporation, bylaws, CCNRs, most recent financial statement, might be the prior year audited or reviewed financial statement, copies of rules, information about special assessments, insurance information, some other things I'm trying to...
Rules and regulations.
I mentioned that.
Yeah.
Right.
That's it.
So also they're going to ask for a statement of account, the escrow company, in terms of whether the homeowner is current, if they have back due assessments.
Or if there are any fines or penalties that are outstanding, they will ask that as well.
Ask if there are any special assessments, what's the nature of the special assessment, and how long is it going to be for, if there's one currently or if there's one anticipated in the future. So, and I forgot, and a copy of the reserve study. Okay, so that's another thing that prospective buyers should be looking at all this stuff, aside from looking at the interior of the unit, you know, and the pool outside, but whether they read it all, I don't know. All right, so next slide here. I was wondering from an accounting perspective, like, well, what about all these expenses associated with foreclosure? And it turns out that what should you do with them? You know, the association, and the point is you should add them to the individual owner's ledger account, right? They're still obligated on the for those expenses until the 90-day redemption period, should they redeem. And the last point here was, what do you do about after the 90th day in terms of the rent and the rent expenses? Well, you're obviously, hopefully, going to be collecting the rent, and it's going to be taxable. It's not exempt from taxes. Assessments, by the way, are typically tax exempt. But in terms of rent and interest and other sources of income, in terms of filming revenue, all this stuff is taxable. That's a whole nother hour we could spend. The point is here is, yes, you have to, the rent's taxable, the rental income, but there's certain expenses you can allocate to reduce that
Yes,
on the
question.
tax return. Yes, sir.
So the rents collected can be used to cover the prior kind of expenses?
Yes, the rents that, the question is, can the rents that are collected, can they be used against the prior expenses? And yes, they are used to offset all of the money that the delinquent owner owed the association. So when that debt is completely paid back, the association on an ongoing basis can pay itself its monthly assessment, but the rest of that money has to be put aside for whoever makes the demand for that money. We're going to skip over the next two slides because we actually
Okay.
covered them, and we're going to wind up with you, Sandra.
All right. All right. Okay, so now it's my turn again. Question came up, someone raised, well, this foreclosed unit, do you record it on the books of the association, right? That was a question I came up with. And if you're going to do it, okay, you should use fair value, less any estimated selling costs. But you're going to see in a later slide, I'm going to say don't record it on the books, okay? So things to consider in terms of fair value would be, I indicated here, the liens on the unit, the cost to acquire the foreclosed units, the physical condition of the property, if the association can rent the property, if it plans to do it, and, you know, the economics of the rental market in that particular neighborhood. But, you know, this is not sort of an easy number to come up with fair value on anything, any asset, as you know here. Sandra, are you going to do this one? Yes.
Yeah, we've actually covered it. The association is not obligated to pay the
Right.
mortgage, and the reason is the obligation is the promise from the prior owner, the delinquent owner, to the bank lender.
All right. So now here's the question about, do we record an asset on the books of the homeowners association or not? The bank still, you know, is in senior position. They eventually will foreclose out the association's ownership. So we just have the unit temporarily. We do have, I would recommend not recording it on the books. We're not going to record the mortgage on the books. So I'm saying if you're not going to record the liability, why are you recording the asset, right? Which is temporary till the bank forecloses. We do have some bad debt expense on lost assessments, collection and foreclosure costs. Again, I said unless the association plans to keep it, don't put it on the books. Most associations don't want to keep these units. They'd rather have an owner in there who's paying the assessments.
And that's probably not even identified in their articles of incorporation, something that they should be doing, owning property and trying to, on a long-term basis, trying to make it into an income property.
I'm not aware of any association, again, I have limited knowledge, that actually owns a unit over an extended period of time. I do know one association that actually acquired a unit, I'm not sure how, and uses it as an office, but all the associations I'm familiar with, they don't own any units, you know,
Okay.
except temporarily. All right. Next question. Accounting. Oh, sorry. All right. Sorry. Well, if there's no asset on the books, nothing to depreciate. Yes.
Are you going to footnote it on the statement that we own it?
You know, I talked
Can
to
you
a.
repeat the question?
His question is, if you don't put it on the book, should you put it in a footnote?
Or some disclosure.
Right.
Other people account.
Or some other disclosure. I talked to a couple other CPAs who specialize in the HOA industry, and they said no.
So it's a good way. If we walk
But-
by it every day and
Well, I don't know how long we're going to own it, for one thing. I don't necessarily agree with them. I think you could certainly disclose that the association took possession of the unit, not obligated to pay the mortgage. I think would be a prudent thing to do, but the ones that I talk to, they don't put a footnote. But
From a legal perspective, we provide notice that the association has completed the foreclosure and that the association is not liable for the underlying debt, and that each of the assessments are paid from the pot of money that is the budget, because people always wonder, do we have to pay the assessment? Do we have to write ourselves a check? And the answer is no.
okay. But like I said, I think it's better to disclose than not to disclose. So, but if you were to put it on the books at fair market value, of course you'd have to depreciate it, and eventually, like I said, a third party will buy the unit. So if you put it on the books, then you're going to have to take it off, and that's a whole nother journal entry, right?
Go ahead.
No.
Repeat.
The question is, if you put it on the books, what's the credit going to be? What's the offsetting entry? I assume you're going to put it under some equity, an equity account, because like I said, the mortgage is not going to go. We're not obligated to pay the mortgage. So,
Okay.
all right. Again, I've pretty much covered. If there's no asset on the books, there's no gain or loss to record. If you're going to put it on the books, you can see it gets messier, so why not keep it simple? And again, bad debts would consist of any lost assessments plus foreclosure and collection costs. Again, I don't know whether you rented it or not rented it, but we do have bad debts for money if we didn't collect what was owed by way of foreclosure. There was a question or two.
We are going to actually wait until we're done, because we're
Okay.
not going to get
We
through
have
this
5
otherwise.
minutes.
Property taxes. The California Code of Regulations says that the owner of a property is obligated to pay property taxes when title vests in the original debtor's successor in interest. Title vests in the original debtor's successor in interest. There's enough fluff in that word for me as a lawyer to say, no, don't pay the taxes. When the first trust deed forecloses, it's on that debt, and they're going to pay the taxes. Is that the official word? It's not the official word, because I can read English, and it says that the association would be obligated. But it's one of those things, yet again, that we never hear of a situation where a county anywhere in California is going after the association for the prorated taxes for the 3 months that the association may have had ownership on the property, probably because it's subject to the senior encumbrances as opposed to a flat-out ownership of that property. So what should be disclosed in the financial statements, which really is a collection of all of the
Right.
questions we've had?
Right. Typically would already disclose already the accounting policy, whether you have foreclosures, non-foreclosures, what the association does about uncollectibles, and its ability to record liens on units. Also, we would disclose if there was a provision allowance for doubtful accounts, if need be. And I indicated here, neither the number of units subject to assessment liens nor the dollar amount related to those liens need to be disclosed. You certainly wouldn't mention specific units, but you don't there's no requirement to disclose that. But I agree with the gentleman earlier in terms of disclosing what happened, and the association owns a unit based on foreclosure would, give transparency and let the owners know what happened to the unit.
The California legislature puts a great premium on privacy, protecting the privacy of the delinquent owner. When the board of directors votes, they have to do so in general session of the board, and they can't use the owner's name. They have
Or
to
unit
use
number.
or unit number. They have to use the tax identification number or track map number, and anybody in the real estate industry knows they can look that up in about 2 seconds. But the legislature wants to protect that privacy, so we have to keep that in mind as well in our disclosures. In the next slide, I briefly talked before about tenants renting units. Rent skimming is a real issue. You might want to jot it down. Civil Code Section 890 has the controlling law on this. If you have any questions, you can email either one of us on that. We talked before about the tenants renting, the association renting the unit. One thing that you need to know is if the association is foreclosed on by the lender and you've entered into a contract as the association with the homeowner, the lender has to honor that lease for at least 90 days. And that was part of the California Homeowner Bill of Rights that went into effect of January of this year to protect the tenants. We always say to our clients, if you're going to enter into leases, they should be month to month to protect the association in case the first wakes up and forecloses. This is you.
Right. All right. So we're really running out of time here, and the taxation issues regarding HOAs. There is a form 1120H if you're not familiar with it. The effective tax rate's 30%. You can also file for federal purposes an 1120 where the rate's only 15%. Association assessments are tax exempt. However, if we've got some rental income, as I mentioned, it's taxable. For state purposes, everything's taxable unless an HOA files for tax exemption, which isn't that hard to do, but it is a process, Form 3500. We've pretty much run out of time here, but I had 6 more slides because I thought we'd have so much more time. And I spent a lot of time preparing them, and I don't have time to go over them. And I was worried because I'm an audit guy, not a tax guy. But cancellation of debt was on the program. It's a big issue these days. It involves some complex computations. Cancellation of debt was something where all of a sudden it became taxable income. You're well familiar with this, right? But there are provisions where it's not taxable, and those provisions, that Mortgage Debt Relief Act was passed by Congress in 2007, was set to expire in the end of 2012. I think they extended it through 2013. We're not quite sure where it is right now. All right, but there's various calculations and ways to avoid your clients paying taxes on debt cancellation, which is considered the sale of a unit. And I'd look at the 6 slides that were added, just yesterday to my our presentation. But
thank you very much. We appreciate it.
Yeah, if you'd like more information, contact me. Thank you.